The private respondent. 80. Item 80, I'm for the private respondent. My lord, a CAN application has been filed, I don't know. But no copy has been served upon us, my lord. My lord, there is the affidavit of service. আমি private respondent কে দিই? কত নম্বর? Private respondent. Private respondent কত নম্বর? Respondent number. Well, this is an application, CAN application for amendment. Got it granted by my lord justice. Copy দিতে পারবো না? Private thing. Private, there is only one private respondent only. Private application will not be this and my lord, be that as it may, my lord, Mr. Shagnik Chatterjee is appearing for the private respondent, my lord. I am praying if this matter can be taken up after Tuesday, my lord. He is out of station, my lord. It's an urgent, my lord. We are out of. Then in that case, it is an amendment.
But the other respondents have not been made a party in the application. Only it is against, let's say, one of the respondents, Pradhan. See, there are other respondents also. He is respond number 3.
My lord, I am not briefed in this matter. Mr. Shagnik Chatterjee is briefed in this matter, my lord. I am praying if this can be taken up on Friday, then in that case, my lord. Only that much I am praying. Three respondents are there, my lord.
So private respondent, he is respond number 3.
Yes, sir.
Service has not been effected on respond number 3.
Lord, I have instruction that I have not received a copy. But
No, service has not been made upon 3.
If my learned friend says,
as well as state,
did I copy?
Sir, you find out state has also not been served. Only the Pradhan has been served. The affidavit shows that only Pradhan has been served with that. That is respond number 2. State has not been served. Affidavit of service filed on behalf of the petitioner is taken on record.
Please kindly takes it up on Tuesday, after Tuesday, my lord. I am praying, my lord. This is the first time I am receiving this copy, my lord.
No, better নয় চলো কিছু করার দরকার নেই এনাকে বলে দিয়ে এমনিতে হারিয়ে হয়ে যাবে But the state was there. You give a notice to the state. There was notice and also copy has been given to you.
Just now I have received, my lord.
But you are not. You have filed your vocal number.
My lord, Mr. Shagnik Chatterjee is appearing for the.
Then how he will come up and again he will say that the copy has not been.
I am junior to Mr. Shagnik Chatterjee, my lord.
No. I am not recording your submissions.
No, I am receiving the copy right now on behalf of Mr. Chatterjee. I am taking it, my lord.
Shagnik Chatterjee appeared for respond number 3.
Yes, my lord.
What is your name?
Shayan Mukherjee, my lord.
Shayan Mukherjee.
Junior to Mr.
Shagnik Chatterjee. নামটা রেকর্ড করে দেব উপরে দিয়ে দেবেন যে কোনো জায়গাটা নামটা থাকবে উপরে দিয়ে দিন আর নাহলে একটা কাজ করি না ওনার নামটা এতে দিন অর্ডারে দিন হ্যাঁ অর্ডারে দিন হ্যাঁ অর্ডারে দেবেন কি বললাম affidavit service taken on record it is found that service upon the state respondents and the respond number 3 is not affected. Mr. So-and-so, learned advocate, seeks accommodation on behalf of Mr. Shagnik Chatterjee, who appeared on behalf of respond number 3. Copy of this application has also been served upon Mr. Mukherjee. learned advocate for the petitioner is directed to serve notice upon the learned advocate for Mr. Devjit Mukherjee appeared for the state. Learned advocate for the state. Is this matter on? When can this, sir?
After
When can the service be completed? By Friday, then on Monday I can place.
my lord, after Tuesday, my lord, I'm praying, my lord. It's a request, my lord. After a request, my
Another Wednesday,
lord. Deeply obliged.
30th April. Okay.
Shahan Mukherjee. I'm
30th April.
deeply obliged.
For the private respondent number 3, my lord, holds the Development Authority, led by Mr. Kolol Bosch.
Minute, I'm here, minute. Minute, I'm here. I'm sorry that I'm not there, minute. Here, minute, on the last occasion,
Yes.
I have almost completed the argument.
Hmm.
I have taken, minute, three certain points, minute. First of all, minute, the delayed approach on the part of the petitioner on the writ court. Second, Millard, that there was no substantial compliance on the part of the petitioners insofar as our offer dated Millard September 11, 2001 is concerned, and the petitioner's understanding of the situation is like this, Millard, that even after 2001 November, we continued with the communication and providing other facilities. It means that we have acquiesced. But Millard, there are certain Millard points which they have raised with regard to the element under the contents of the Millard, the resolution taken by the Haldia Development Authority. Millard, they have referred categorically. That is a kind of Millard, the discussion which the board had held, and Millard, that is absolutely Millard interdepartmental. Be that as it may, Millard, but ultimately, from 2001 to 2025, 24 years have passed. Now, question is that admittedly, there are certain disputes. The power and the periphery of the writ court, I never said, Millard, at the cost of tiring repetition, I submit, Millard, with humility, that I never said, Millard, that the writ court is powerless. I said, Millard, it is a discretionary relief, and every discretion must be informed by reason. That is the law, Millard, as I have understood, Millard, subject to correction by your lordship. But in this case, Millard, the diligence and Millard on the part of the petitioner, Millard, or rather I would say, Millard, in brief, Millard, the conduct of the petitioner, that is to be looked into. It is an equitable jurisdiction, and in this adversarial proceeding, Millard, the duty of the petitioner to plead and prove that there was no fault which is to be attributable to them, Millard. And basically, at the end of the day, Millard, my understanding is that in every writ petition, a citizen or any organization of the petitioner, Millard, when they come to the writ court, they are basically seeking execution of constitutional reasonableness. Now, this execution of constitutional reasonableness, Millard, has to be tested on the anvil of constitutional right as well as the other legal rights. The fact in this case, Millard, in nutshell, Millard, that we made a definite offer. They made a counter offer. And Millard, certain facilities that were to be provided, Millard, this was provided by the petitioners. And not only that, one of the contentious issue, Millard, that was raised passionately, Millard, consistently, Millard, by the petitioner is that the facilitating the arrangement of, Millard, the electricity, for which, Millard, we have categorically stated, Millard, in 2006, Millard, it was provided. 2004, Millard, we registered a particular land And not only that, we provided 15 acres of land to the petitioner. And not only that, Millard, the remaining 35 acres, possibly Millard, subject to correction, this could not be matured because of the counter offer made by them. And they said you consider this aspect. Question is, Millard, that whether this issue is justiciable. I said that X amount of money is required for the completion of the agreement, and you have to pay it. Now, Millard, the price of the surrounding area, Millard, that has been escalated. Now, tomorrow the question might pop up, or Millard might come, that as to why after 24 years, when there is admittedly a non-performance of the contract, there is a breach on the part of the petitioner, why an authority, which is an authority under Article 12 of the Constitution of India, has decided to, Millard, to execute a registered instrument in favor of the petitioner at a price that was initially agreed upon by the offer letter 11 September 2001 at the rate of 5.5 lakh per acre. And today, Millard, the price has been escalated to the tune of rupees 15 lakh that has been demanded. Now, the question is, Millard, whether this particular issue can be, Millard, decided, adjudicated, Millard, in the writ court. Assuming, not admitting, Millard, that there is, even if there is an element of arbitrariness, but the agreement which started its journey in 2001 September and ultimately ended, Millard, if I say, Millard, 2004, 15 acres land, 2006 electricity. After that, Millard, 2008, this petition was filed. Now, question is, Millard, the journey which was set about in the year 2001, and after 7 years, and more particularly on the anvil of existence of the, Millard, the counter offer, whether there was whether I can say, Millard, I put this question to myself, that the attendant circumstances and the records show that there is a concluded contract, number one. Number two, Millard, whether there is a promise which is executable, Millard, in the court of law on the anvil of the facts, Millard, which parties have exchanged, Millard, through their pleading and documentary evidence. These are the factors, Millard, to be considered. In my respectful submission and my humble understanding of the law and facts, Millard, I would say, Millard, that the issues that have been raised, Millard, very passionately, very sincerely by the petitioner, Millard, these issues are not justiciable, Millard. Even then, Millard, assuming but not admitting, Millard, there are certain, Millard, things which might disturb the conscience of the Constitutional Court. And why I say, Millard, that I would, Millard, try to, Millard, submit, Millard, that a proposition of law regarding this promise and the, Millard, the concluded contract. I would refer to a judgment. My senior friend, Millard, the advocate on record, Mr. Maiti, is there. Millard, that yes, because, Millard, first of all, Millard, I have made a specific offer, Millard, in the year 11 September 2001. That is on record. Admittedly, Millard, the offer that was made to the respondent, they could not comply with within 2 months. There was an element of counter offer. Now, in this case, Millard, that they made a specific request to us, Millard, kindly lower down the price, because this was not possible for them, and infrastructural facilities that was supposed to be provided to them, according to them, Millard, that was not provided in time. But these issues are not interrelated. That is an independent of the other issues. That you kindly scale down your price that has been offered to us. Under these circumstances, whether I can, Millard, submit before your lordship, whether I'm correct in submitting, that the offer of the respondent authority was conditional. The petitioner could either accept the offer, reject the offer, or make a counter offer. The petitioner did not fulfill the condition in the offer of payment within 2 months period. Hence, the payment made thereafter was a clear instance of a counter offer, and it was accepted by my client, accepting authority. And now, when the offer is conditional, the offeree has the choice of either accepting the conditional offer or rejecting the conditional offer or making a counter offer. But what the offeree cannot do when an offer is conditional to accept a part of the offer which results in performance of the offeror, are then reject the condition subject to which the offer is made. Miller, under these circumstances, the facts of the case, Miller, it clearly suggests that the initial offer never turned into a promise. And at best, it can be said that it was only the counter offer upon which the parties were added in. But I would say, Miller, that is also a fragmented understanding of the situation in a way, because 15 acres, when I did stop his journey, Miller, in 2004, when I Miller, executed a deed, Miller, 15 acres of land, Miller, in the way back in 2004. But today the situation is completely different. Miller, there are decisions or Miller, the propositions, Miller, which say, Miller, that in a contract which is in respect of a land, Miller, time is not always the essence of the contract. Even if I assuming, Miller, that is correct, not admitting, even then, these are all disputed question of facts. I was supposed to do certain things in the contract, under the contract, and I could not do it. And I said that you had to make such thing within a time, you did not do it. And it requires a trial on evidence, oral and documentary evidence. The question is why the writ court will be burdened and troubled with such exercise when, Millard, the insurmountable pressure, Millard, has been, Millard, imposed upon your lordship. I forget for a second, Millard, that let us forget about the pressure, insurmountable pressure, Millard. Even then, Millard, the question is whether is it a proper case where the writ court will rise to the occasion and will, Millard, come in aid of a person who himself is not a diligent at the time when he ought to be. And according to me, that the situation at the cost of tiring reputation, Millard, I submit, the situation never turned to be a promise. The promise never turned, this initial offer never turned to be a promise. There was no concluded contract, and the remaining 35 acres of land, which they are now, Millard, claiming that to be executed, Millard, this possibly cannot be done. That is my humble understanding, Millard, by the writ court at this juncture. And the part of the, so far as, Millard, the question is whether the provision of electricity, Millard, whether it amounts to acquisitions in the continuance of the contract. Millard, electricity, it has been held many a times, Millard, after promulgation of, Millard, Section 43 of the 2003 Act, that a person's right to get electricity, Millard, is a fundamental right, and writ court can always say that even if he is a occupier without any contract, if he sits on the land, he has a right to get the electricity. That is a different, and that there is no question of acquiescence. There are certain things like, Millard, suppose, Millard, imagine a situation, Millard, where I have given undertaking and which stands against the fundamental right. And if I want to retract, even then court says, Millard, there are certain occasions that there cannot be estoppel or acquiescence against a fundamental right. So, Millard, the continuance of the electricity, my acceptance of payment, Millard, at a later stage in 2004 at a rate which was offered to them, Millard, that also does not amount to acquiescence, because as an authority, it's at the end of the day, Millard, the question that will envelop the entire authority, that what was the occasion for us to give it this land to a particular business house by a state authority at a price that was fixed in the year 2001, when the same authority has given the land, surrounding land, Millard, or in the area contiguous to this land, which the prevailing price is much higher than that of the price that was decided. because ultimately it's a public money, my lord, and I have to fetch a good price, my lord, for the authority. And other companies have given me, my lord, much higher price, my lord. So it is a question that whether, because time flies, my lord, and with the changes of time, my lord, ultimately, my lord, the money also matters. It is directly proportional, not inversely, my lord, because appreciation of the land and, my lord, the market value of the land, these are all relevant factors to be considered, and these cannot be brushed aside, my lord. And no one can make such unreasonable plea in this curial combat in any form whatsoever, that first of all, my lord, in order to arrive at a decision, no, you have to register the 35. It is virtually, it's a specific performance of contract filed under the guise of a writ petition. Yes, my lord. The copy, my lord, possibly with, my lord, I'm sorry. The
Yeah.
copy is with, I'm sorry, my lord. I could not hear your lordship's command, my lord. But the judgment, my lord, I undertake to file it tomorrow, my lord, since I am not in court. My learned senior is there, my lord, who has given liberty to address your lordship, my lord. Otherwise, I am not armed with the copy. I have the copy of the judgment, and the reference of the judgment is 2005, 2006 5 SCC. Sorry, my lord, 2007 9 SCC 531, 2007 9 SCC 531, my lord. It is the Food Corporation of India, my lord, this judgment. I shall, my lord, submit it tomorrow, or, my lord, if your lordship gives me a chance to file a written argument, my lord, I shall annex it. The reference is this, the principle of law as enunciated by the Supreme Court, my lord, that is there, that when the offer, it was held, my lord, whether when offer is conditional, if the offeree has the choice of either accepting the conditional offer or rejecting the conditional offer, or making a counter offer. But what the offeree cannot do when an offer is conditional is to accept a part of the offer which results in performance by the offerer and then reject the condition subject to which the offer is made. Hence, the initial offer never turned into a promise. It was only the counter offer upon which the parties were added. Now, Millard, 15 acres part, Millard, 2004, that has completed. Now the remaining part, Millard, and Millard, and Millard, by a letter dated 27 January 2006, the respondent authority demanded the balance of the premium for transfer of 35 acres land. And this was, of course, an offer to allow the petitioner to gain possession over 35 acres land. Why did I submit this, Millard? Because this might, Millard, the petitioner might come up with this argument, and they said that in January 2007, 2006, it is the authority who had demanded the balance amount. Now, the question is, when the writ petition is considered, taken for consideration today in 2025, I am possibly not entitled to make this submission before this honorable court that the contemporaneous stone has, that has been lost by a flux of time. So, Millard, today that demand, or the today, Millard, it has lost its force, and Millard, it is a right at best, and if they have filed the suit, it is a suit of a civil nature, and it is clearly hit by Section 9 of the Code of Civil Procedure, and it is basically asking for a Millard, seeking a specific performance of contract, Millard, and the petitioner was not at all, Millard, diligent in pursuing its own right, and Millard, accordingly, in fine, Millard, before I say Omega, Millard, that this curial combat must be put to an end with the dismissal of the writ petition, for the simple reason, Millard, the issues are not justiciable. The writ is hopelessly time-barred, and Millard, third, even if the right exists, Millard, the remedy is lost by reason of a flux of time, Millard. And under no stretch of imagination, Millard, any relief can be granted in the present facts and circumstances. And I will submit, Millard, that delay part decision I will place, Millard, If your lordship kindly give me 5 days, 6 days time, my lord, I will come up with a written notes of argument, no further argument, my lord. And if they completely reply tomorrow, my lord, I will also take note of that. I will try to, my lord, deal with the argument according to the best of my ability and understanding, my lord. And I'm extremely grateful, my lord, for your lordship's inherent generosity and patience shown to us, my lord, because many a times I sought for adjournment, for which I tender my apology to my petitioner also, because there was certain constraint, my lord.
Okay. So you conclude your so far as the argument.
Yes,
That is
yes, everything is concluded.
okay. Yes, Mr. Gupta.
We keep it any day next week for us to give a 15 minutes time, and we shall give.
Okay. You will be filing in a written notes
If your lordship grants us time, my lord, we can.
kindly because the judgments have been given already. Copy. Mr. Basu,
I shall, my lord. I shall. By Miller 1 week time, by next Monday, I shall file.
Next week, we shall come with our written notes and confirm.
okay.
And even
And Mr. Basu, if you intend to put in any written notes, you can put in
Yes,
because
yes. Yes,
they
I
have
shall.
also relied on some propositions of law. I think that has not been dealt
Yes,
with
yes.
in the oral argument. So,
Yes, I will. Shall. Yes, I shall, my lord. I shall deal with it. I shall deal with it.
Mr. Kollol Basu, learned advocate for respond number 2 and 3, Haldia Development Authority, who concludes his argument. Mr. Choyan Gupta, learned advocate for the petitioner, seeks to make his lies. Please, this matter, I top it up. Assign কবে আসবে? Recess করে বলে। 30th April?
30th, I have one matter in the Supreme Court, my lord. I will do here instead of in place of it's 30 any day, my lord.
7th after 7th,
29th, as your lordship pleases. As your lordship pleases.
after 7th May.
I deeply obliged, deeply obliged,
Contact a date বলো।
deeply obliged.
9th May.
9th May is a holiday.
I'm deeply obliged.
No, 9th May is a holiday.
Oh, 13th. चलो 13th
Deeply
May.
obliged.
13th.
Deeply obliged.
Yes.
Deeply obliged.
Yes.
And would your lordship, is it lordship's pleasure that we shall come with the notes on that?
13th May 2 p.m. করে দেবো।
Kindly mentions that if the parties intend to
2 p.m. my lord. 13th May, 2 p.m.
To file any written notes of argument, liberty is granted to the parties to file written notes of argument.
Deeply obliged, my lord. Deeply obliged. Deeply obliged.
Next. Please.
Not reply. Yes, he was supposed to make further submissions. Your lordship had said that I'll.
Not on the previous occasion at the time of my submission, we have relied on
কপি হোক ম্যানুয়ালের একটা কপি
clause 827 requires 827. While it may be realized that the railway have a prior right to acquisition and utilization of the land adjacent to railway boundaries, the railway administration can only insist on previous information being given by the revenue authorities of the local government when such lands are assigned to specific purposes. For the prevention of encroachment on railway land, such as by the erection of building and platforms, gradual accrual of the easement rights, such as right of way and right to discharge from water, it is desirable that sufficient open space may be provided between the railway boundary and the nearest place of any of the structure erected on adjoining land. Says the interest of the railway will be suitably safeguarded by providing for an open space of approximately 30 meters being left between the railway boundary and the nearest edge of the building constructed on adjacent land, and extra space will be left being governed by local conditions. And it requires and no objection will be prior no objection is to be obtained if it is not kept and or within 30 meters. I relied on this point on the previous day, and it is the specific case of the petitioner also that it is within 30 meters and no objection has been obtained from the railway. While learned friend made submissions against this point, my learned friend relied on several judgments of the Supreme Court of India and other different coordinate high courts, stating that such a manual or a circular is not always binding. On the question of their legislative strength, in reply, my lord, on the previous day, actually, in so detail, I did not cover. The railway manual was enacted under the provision of Indian Railway Board Act 1905. A very short act. I am reading the section 2. Investment of Railway Board with power under Indian Railways Act 1890. The central government may, by notification in the official gazette, invest the Railway Board either absolutely or subject to conditions. A. With all or any of the powers or functions of the railway of the central government under the Indian Railways Act 1890, with respect to all or any of the railways, and B. The power of the officer referred to in section 47 of the said act to make general rules for railway administered by the government. Next, section 3. Mode of signifying communications from the railway board. Any notice, here the language is important. Any notice, determination, direction, requisition, appointment, expression of opinion, approval or sanction to be given or signified on the part of the railway board for any of the purposes of or in relation to any power or function with which it may be invested by notification under section 2 shall be sufficient and binding if in writing signed by the secretary of the railway board or by any other person authorized by the railway board to act in its behalf in respect of the matters to which such authorization may relate. And the said railway board shall not in any case be bound in respect of any of the matter aforesaid unless the same is in writing and signed. But I am relying on the words expression of opinion. It
This is
covers the
section 2
section 2 and 3. 2 read with 3.
of the, what is this act? Railways Board Act.
Indian Railway Board Act 1905. It is still valid and operative.
Give a copy of it.
I have only one book, my lord, and
Yeah,
read
yeah.
over. Okay, but manuals are made under this act.
And where it is mentioned that this manual has been framed, the rules of the manuals have been framed as per this act.
Not manual পুরো কপিটা তো নেই আমার কাছে।
Hmm?
The manuals are enacted under this provision. And in section 3, the words expression of opinion that covers a manual. It does not require that it should be in the form of rule or regulation or anything like that. Therefore, it has got a statutory force.
The rules are framed under which act?
Yes.
Which act?
There are two acts. One is Indian Railways Act 1890. And this is the other act where the railway board is authorized to have any rule, regulation, direction.
Does this manual in the preface says that this manual has been prepared in terms of any of the act of the railways?
No, that is not mentioned, but the member engineer railway board is the, and it is specifically stated that it is emanating from the railway board. The board is empowered under the Act of 1905.
Oh,
Therefore, it has got a statutory force. And in this connection, my lord, my learned friend on this point has cited some judgments. I am not referring one by one in detail. That will be a wastage of your lordship's time. What I am submitting is, it is a settled principle of law that if there is any conflict between the statute and the judgment in any manner, the statute shall prevail. On the question whether it is binding or not, that judgments were shown by my learned friend. In all my learned friend submit that this railway board manual is not binding. But since it is following by being enacted by the railway board, and the railway board is empowered under a statute, and section 3 of the statute specifically says that any expression of opinion in any form shall be sufficiently binding. Therefore, the binding nature is established from the act itself. And any contrary view of in any judgment showing any doubt as to whether it is binding or not, the statute of 1905 shall prevail. This is my first submission on that point. My learned friend took another point regarding the wide circulation, whether it is how the private respondent can come to know. But firstly, like other enactments, this is available. And secondly, my lord, it is also available in the internet nowadays. Therefore, on this question also, it cannot be said that it's a very secret document. It is not supposed to be known by all, and therefore it can be that any person may be at liberty to violate. Available like any other statute.
yes.
Next point is, my lord, my learned friend has another point that since the concerned municipality is authorized and empowered by the West Bengal Municipal Act regarding all these points, they can control, they can supervise the raising of buildings and all this. Therefore, this manual has no manner of application. Power is in the hand of municipalities. In this regard, my lord, I am starting with the Constitution of India. Rule of the Constitution of India.
The Constitution, third bit.
7th schedule of the Constitution of India, there are three, list 1, list 2, and list 3. That is a clear division of subjects, which will be under the government of India, which will be under the state legislature, and which will be the concurrent. Pillar 1, that is the union list, NT 22, covers the railway power, rests the NT 22, that is list for the union legislature. NT 22 covers railways.
Yes.
That includes the entire power of the legislative power to make rules under the railway. And regarding the power of the municipality, that is under list 225. List 2 is the state list 25, local government, that is to say constitution and power of municipal corporations, improvement trust, district court, mining settlement authority, and other local authorities for the purpose of local self-government or village administration. Now, this is a particular case of such a nature where there is overlapping of provisions. A building is being enacted that is also under the power and authority of the municipality. It is so close to the railway property that this particular rule, clause 827 also comes into operation. Submission of my learned friend was that in view of the West Bengal Municipal Act, the clause is inoperative. In that, come to Article 46 and 247.
Yes.
Starting from 245. Extent of laws made by the Parliament and by the state legislature. 1. Subject to the provisions of the Constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. 2. No law made by the Parliament shall be deemed to be invalid on the ground that we do have an extraterritorial operation. This is important for me in this case. 245 and the provisions of Article 240. For the four clauses of the past, notwithstanding anything in clause 2 and 3, Parliament has exclusive powers to make laws with respect to any of the matter enumerated in the 1-7 schedule Constitution referred to as the Union. Notwithstanding anything that is relating to not relevant to the present case. I am reading the three. Subject clause 1 and 2. The legislature of a state has exclusive power to make laws or such state or any part thereof with respect to any of the matters enumerated in the 7th schedule. Therefore, it is the clear constitutional mandate that the Parliament of the power of the Union of Legislature is unconditional under Article 246 of 1 as well as 245. That the power of the state legislature or operation of any of such power is subject to clause 1. It is an admitted position that this 1905 Act empowering the Railway Board, it is enacted under the list 1 Union of India. The central legislature authorized the state, the Railway Board to make provisions. Therefore, that is being covered under Article 245 plus 2 and 246 plus 1. And the municipal authorities are deriving the power under the laws made by the state legislature. and operation of the same under Article 246 clause 3 is subject to operation of the any provision of the enactments made by the Union of India under the Union list. Now, this particular provision of the manual, which is derived under a law enacted under the list 1, that cannot be inoperative by operation of a law made under the list 2, a state legislature. Well, it is authorized, therefore this provision shall be inoperative. It cannot be held. It will operate, 1905 shall operate unconditionally, and this particular clause 827 being enacted under that act, that also shall operate unconditionally.
Okay.
And the state act is in addition to and not in by overriding this provision. So municipality may have power, municipality may take care, but this railway manual, that shall remain operative, and that is binding both on the municipality as well as on the private respondent. Next point was taken that it is a directory provision, since it has no connected penal provision, that if it is not violated, then what? Lord, it is a settled, it follows from so many judgments of the Honorable Supreme Court that whether a provision is directory or mandatory, any connected penal provision is not sufficient test. Another test is there to adjudicate whether compliance of it is desirable or compliance is compulsory. If it is found that the compliance of a particular provision is compulsory, then it shall be treated as a mandatory provision, or if it is found that it is just desirable, then it may be treated as a directory provision. Here the provision under Article 827, not article, clause 827, relating to minimum distance, and if it is made within that 30 meters prior consent, that is created for the purpose of protection or what can I say, stability of the railway property. But it is a settled principle that any railway property, structure, line, or overhead connection, these are actually infrastructural in nature. The Railways Act is an infrastructural legislation. And it is also a settled principle that some enactments are there, like pollution laws, like infrastructural legislation. A sustainable development and sustainable protection is required. In such cases, my lord, what my learned friend says, that in anticipation, no order can be paid. On this point, I have to submit. I am drawing a resemblance, first kindly pardon me. That's a court. Deal with the pollution. The pollution. It is not the policy there, or the judicial process, that first there shall be proof that yes, air or water is absolutely polluted. Then the court will interfere. That is not followed. Some guidelines and procedures are there. The moment any violation is found that procedures are not complied with, the National Green Tribunal or the Supreme Court, as the case may be, they immediately interfere. Object and purpose is to prevent pollution, and that fundamental concept that there should be a sustainable development, and that should be necessary. Not subject to a lot of correction. My submission in case of infrastructural legislation also, that point of sustainability and sustainable development, that is to be kept in mind. Something will happen. The constructions will be destroyed, and thereafter the court will be authorized to interfere. That is not the legislative but judicial principle. If there is anything which is likely to cause any harm, that is a sufficient ground when the court can take preventive steps and preventive measures. Doctrine of sustainable development, which is applicable very frequently in the field of pollution, that is applicable also equally in the field of
Yes.
infrastructural legislation. Here, difference or distance between the railway track and the face of the building is, I am told, only 5 or 6 meters. Therefore, any kind of collapsing or any destruction of the building for any kind,
Yes.
that is likely to cause serious damage to the infrastructure. And therefore, at this stage, the court is not powerless.
Yes.
Because these are the main points taken against the railway map. But as the other points are left, the petitioner will, and only one judge will be heard. It is not reported. In connection with a contempt application. Honorable Justice was pleased to direct one block land and land reforms officer to refer an application for prior consent to the railway authority. The entire full judgment is not available. This has gone to the railway authority and subsequently the application has also been forwarded. It have to be. A similar question came up, whether the consent of the railway authority is required or not. That point topped up. This honorable court was pleased to refer the matter before the railway authority for their opinion. It was not held that this provision is infructuous, therefore railway consent from railway is not required.
But what is the fact of this case? What is the fact of the case? What is the fact of this case?
You know, I am told by my clients that this question came up there. A construction was made within 30 meters without the prior consent of the railway.
Like, so,
Whether permission is required or not, that question crossed back. And under the same provision, 827.
Yes. Who is the other respondent to?
I'll be replying to this because he's uh, opened his arguments anew. And your lordship had promised that if he does, I'll be getting the chance to reply to this. So therefore, your lordship kindly fixes a date. I'll just not take very much time because more or less I've in my humble submissions before on the earlier dates I've covered these, but then I'll just reiterate and maybe there might be an area where I might have to distinguish. So therefore, kindly keeps a date so that I can go through this.
Yeah.
27 says.
When will Mr. Tanmoy Mukherjee make his submission? After he concludes. You conclude on the
I'll-
next date, then you make
Uh,
Mr. Pinaki.
After tomorrow I have something.
Next
They
week.
can record it on any subsequent date.
Mr. Pinaki Ranjan Chakraborty, learned advocate appearing for respondents 6 and 7, Railways Authorities, concludes his arguments. Mr. Sudeep Shanna, learned senior advocate appearing for the respondent number 7 to 10 in WPA 10868 of 2023 and respondent numbers 8 to 11 in WPA 29103 of 2023 seeks accommodation to make his replies. Follow next week. Date bolo. Date bolo. Is this matter on 5th May? Is it 5th May? 5th May. 2. You need to 2 p.m. So after he concludes whatever replies you have to make, you make your replies and conclude the argument.
Whatever.
Mr. Chakraborty, you kindly give a photocopy of this rule and the section 2 and 3 of this act, if you can.
Yes, my understanding should make a xerox and in course of this day.
No,
Photocopy of only the rule.
only the rule. That act is available in the. এটা করে গেল কোথায়?
These are not rules. I'll make my submission.
আমার হাতের লেখাটা এতে আছে, এটা রাখো। নোট নিতে হবে, ওটাকে ওদের রাখো। Next.
Matter, my lord.
On behalf of the petitioner.
My lord. I have them that, my lord, that was mentioned and it has updated. I have some through email as well as through my lord speed post.
They are the private respondents.
But speed post, my lord, I have served the respondent number 7 and 8, my lord.
Private.
Been illegally raised the illegal construction, my lord, and my lord through email. I have served the landed advocate for the state and as well as for the my lord Gram Panchayat.
Oh.
And also, my lord, prior to mentioning, I intimated the state and the my lord, the case has some urgency, my lord, which is why this has been mentioned. And I am, my lord,
grateful that your lordship has allowed my mention for
No.
upgradation.
Yes.
My lord, the case in a nutshell is that, my lord, the petitioner is the owner of, my lord, of the property, my lord, that has been mentioned in paragraph number 3 and 4, my lord. And there is no doubt and there is no dispute about that. Now, my lord, in the year, my lord, 2023, a writ petition was moved by the petitioner, wherein, my lord, an order was passed directing the Gram Panchayat to consider, my lord, kindly come to page number, my lord, 30 of the writ petition. The order will be there. It was, my lord, passed by my lord Justice Chompa Sarkar, directing the Gram Panchayat to dispose of the representation made by me, and her ladyship also made a detailed observation as to what particular process will be followed. Thereafter, my lord, this order was not complied with. I served the, my lord, contempt application. That is also, my lord, appearing at page 44 of the writ petition. Then, my lord, a contempt application was filed, my lord. There, my lord, the order was passed, my lord, for service. And then, my lord, on 24th April, my lord, will find that order at page 51 of the writ petition. Who was issued? The Gram Panchayat, my lord, Pradhan of that, my lord, Gram Panchayat was directed to my lord person present. After passing of this order, a reasoned order was, my lord, passed. In the meantime, a hearing was scheduled, everything. My lord will file that reasoned order at page number 55 of the writ petition.
Yes.
But in the writ petition, my lord, kindly see, my lord, the ordering portion at page 56. Under the facts and circumstances, the undersigned is bound to act within the scope of the West Bengal Panchayat Act 1973 and the rules framed thereunder. It is therefore directed that the private respondents, that is respondent number such and such, shall stop any further construction on the plot of land in question. Matter be further referred to the SDO in terms of section 23 subsection 6. My lord, this order was, my lord, also forwarded to the private respondents as well as to the SDO. Additionally, I have also communicated. Then, my lord, this order was not, my lord, acted upon. That's why, my lord, on 19th of August, page 57 of my writ petition, I made a detailed representation, my lord, requesting the SDO to act in terms of the section, my lord, thereby scheduling a hearing and, my lord, passing an order. My lord, thereafter, my lord, there is no answer from the SDO with regard to my application. Then, my lord, I filed the writ petition on, my lord, 3rd September 2000 and, my lord, 24. My lord, may I have your lordship's kind leave to file a supplementary affidavit, my lord, taking on record the subsequent facts, my lord.
What happened to the contempt petition?
Contempt petition is still, my lord, pending. It's
Then?
still appearing, my lord. I am uncertain about the item number, but it is still pending. My lord, kindly sees, my lord. All of a sudden, my lord, at page 6, I have annexed a notice issued by the Gram Panchayat, my lord. At page 6A, my lord, I have annexed the legible copy. My lord, I have taken this point, my lord, in my supplementary affidavit that, my lord, the Gram Panchayat Pradhan acted beyond the scope of the, my lord, statute, thereby directing the petitioner to cause self-demolition of the illegal structure, which he has not made, has not raised, my lord. My lord knows it very well that this section only says that Gram Panchayat will cause an inspection as to whether any plan was obtained or not, and thereafter will pass an order recommending the matter to the SDO, my lord. Thereafter, my lord, the SDO, respond number 2, my lord, issued a notice of hearing at page 7 of my supplementary affidavit.
No, no, this You are instructed to demolish or remove whose construction is to be removed? Of the private respondent.
The land is mine.
Hmm.
The construction has been raised by them.
Oh,
My lord, in the year 2019.
what was the order passed? What was the order passed again?
My lord, in the earlier date, my lord.
No, no, this. Yes, earlier.
Earlier date, my lord, kindly come to my lord.
No, page 56, the order passed by the Pradhan.
Yes. In my specific case, I have also mentioned that I purchased the land, my lord, in the year 2019. Then, due to the outbreak of the, my lord, COVID-19, I would not initiate any construction. I have not applied any plan. Only the plot is mine. In the supplementary affidavit, I have also annexed the document showing my ownership also. Then, my lord, it has been specifically mentioned in the reasoned order passed by the my lord Gram Panchayat, Shubir Kumar De, respondent number 8, such and such,
Stop any further construction.
acquired no permission from the Gram Panchayat. My lord, at page 55, my lord, the reasoned order. Then, my lord, at page 7, my lord, are you showing, my lord, that the SDO, my lord, scheduled a hearing, my lord, 6th December of the last year. I appeared, my lord, with the relevant documents and I submitted everything, though everything is on, my lord, record. Then, my lord, again, on 15th of January, I was again directed to appear to submit the same document that I have already submitted. My lord, the 15th of January order, my lord, will find at page 8.
এটা দিন না পঞ্চায়েত একটা ওখানে আছে কি করে You are aggrieved by which order?
But I am aggrieved by the non-implementation of the section of the statutory duty by the subdivisional officer in the respondent number 2 hearing. That, my lord, he has conducted the hearing not once, more than once. He has all the documents of mine showing my ownership and also the reasoned order passed by the, my lord, Gram Panchayat. The subdivisional officer, my lord, is expected to act within the, my lord, four corners of law. He is a, my lord, statutory body, my lord, and he is not discharging his statutory duties.
Where is the document of hearing?
My lord, at page 7, my lord, notice dated 22nd November 2024 was issued, directing me to appear before the subdivisional officer on, my lord, 6/12/2024 at 12 noon. I appeared, my lord. I submitted all the documents which were available with me. Thereafter, my lord, after maintaining a stoic silence, then, my lord, on 15th of January, another notice was issued. At page 8, I have annexed that notice.
Date of supplementary.
Supplementary, yes, page 8 of the supplementary. Date, my lord, may I read? As discussed in the hearing dated 6th December 2024, you are directed to submit the following document to the office of the undersigned within 22nd of January for further course of action. Despite the fact that all the documents that has been mentioned herein, I have already submitted. Again, I appeared and submitted the document, but this time what the petitioner did, my lord, he made a list of documents that are being submitted and obtained a seal on. Page number 9 of the supplementary affidavit will be that list. Then, my lord, kindly come
But
to
then
page
this
number.
action of the SDO is covered in the contempt application.
Well, a contempt application, I have arrayed him as a party contemptor, my lord. But it was fallen from her ladyship that the order first has to comply with the Gram Panchayat. Thereafter, the SDO. My lord, I have annexed the order also, my lord.
But then Gram Panchayat has complied the order.
My lord, that is for that, my lord, contempt is, my lord, still, my lord, pending.
Gram Panchayat has complied the order. The court in the previous order has directed to act in accordance with 23(5). Correct.
See,
He has
my lord,
passed order. He has recommended the matter to the SDO. SDO has issued a notice. Now the SDO is not functioning. The matter is contempt application. The similar issue is pending before the contempt court.
Kindly come.
So what prompted for filing a separate writ petition?
My lord, kindly come to a separate, my lord, cause of action has arisen. My lord, kindly appreciate for a moment. Kindly come to page number 49 of the writ petition. I have annexed the order whereby service upon the contemptor was there. A copy of the contempt application along with the server copy of this order be served upon the alleged contemptor number 1, that is the Gram Panchayat Pradhan, not the contemptor number 2 being the SDO. So copy was not served upon him.
If it is not served, then you approach the court taking up contempt matters that this SDO is not functioning in accordance with the order passed by the Gram Panchayat.
My lord, may I
What
ask
is the phrase cause of action? The similar issues are before the contempt court.
My lord, may I, my lord, say this with humble. My lord, a recent order has been passed by the, my lord, Gram Panchayat. After filing the contempt application, after issuance of rule. Now, my lord, that recent order, my lord, was served upon the SDO as well to act in terms of the statute. Now, I have also approached the SDO by a letter dated 19th August.
No. If the SDO does not act, then 23(5) in the previous order also takes the ambit that SDO has to function in accordance with 23(5). So contempt court has the jurisdiction. Why this was not brought to the notice of the contempt? That the SDO, after passing of the order by the Pradhan, he is not acting.
No.
23(5) says, if you come to the order in the previous writ petition, it says that if there is violation, the Pradhan will take steps in accordance with 23(5). What is 23(5)? If there is evaluation, he has recommended the matter to the SDO. Now the SDO is a contemptor too in your application in contempt petition. If he doesn't act, then it is up to the petitioner, the applicant, to bring it to the notice of the court that this has not been acted upon. Why is separate writ petition?
Separate, my lord, cause of action has arisen, my lord.
No.
I have
Bring it to the notice of the contempt court taking up the matter.
My lord, I have appeared before him also, my lord.
No.
But since, my lord,
No, I don't find it.
my lord, this illegal
Contempt petition is pending. You go there and you make your submissions. The SDO is not acting in accordance with 23(5). You say that he is also a respondent in that application. Contemptor 2 in your application.
My lord.
Okay. Affidavit of service filed on behalf of the petition is taken on the record. Despite service, none appears on behalf of the state, KS state. Will appear.
But I served, my lord, Mr. Shivato Banerjee.
He is not here. Mr. Mahathir will appear. Mr. Lolit Mohan Mahathir, an additional government tutor who usually appears on behalf of the state, is requested to appear in this matter. This writ petition has been filed seeking for direction upon the respondent authorities for removal of unauthorized construction over dag number 4843 and 4844, jail number 54, Mauja Fulsara, LR Khutian number 7304, in terms of section 23(6) of the West Bengal Panchayat Act 1973. And also consider the representation dated 19th August 2024 made on behalf of the petitioner. The petitioner contains that previously in a writ petition being WPS 6531 of 2023, orders were passed directing the Pradhan Pulsara Gram Panchayat to take appropriate steps for demolition of the structure undertaken by private respondents upon causing inspection and hearing the parties. Since no steps were taken, a contempt petition was filed being CPAN number
1380 of 2000 and
no. CPAN number 1380,
page 49.
2023. And thereafter, this is WPCRC is arising out of that CPAN number. Thereafter, a rule was issued against Pradhan Fulsara Gram Panchayat in WPCRC 43 of 2024. During the pendency, the order was passed after you filed the contempt petition.
But I filed the contempt petition. No, my lord, I filed the contempt petition.
The order by the Pradhan was
passed
after-
after issuance of the rule.
thereafter. The Pradhan passed orders directing respond number 8 and 9 to stop further construction over the plot and recommended and referred the matter to the subdivisional officer Bonga, North 24 Parganas, with a recommendation to demolish the illegally constructed buildings over the plot in question. Since no steps has been taken by the subdivisional officer, the petitioner is constrained to file the present writ petition. Mr. So-and-so, learned advocate appearing for the petitioner, submits that despite repeated persuasion, the subdivisional officer has not acted in terms of the order passed by the Pradhan for demolition of the structure. He seeks for appropriate orders. Mr. Mahathir, a contempt petition is there, and a subdivisional officer is a container number 2.
He has to pursue with the contempt application.
Mr. Mahata submits that Mr. Mahata, additional government leader, submits that since the subdivisional officer is container number 2 in the contempt petition, the recourse is upon the petitioner to approach the court taking contempt matters. Para. This is a second round of litigation. Previously, this court in WPA 6531 of 2020 passed the following order. Is 32. Hence, Since no, parallel. Since no steps were taken, a contempt application was filed by the petitioner being CPAN 1380 of 2023. And ultimately, a rule has been issued against Pradhan Fulsara Gram Panchayat in WPCRC 43 of 2024. With a direction to compliance in the meantime. It was 24. VD order dated 25th April 2024. Thereafter, the Pradhan Fulsara Gram Panchayat has passed order on 2nd June 2024.
My lord, on my lord, 10 June, my lord.
Sorry, 10th June, right. 10th June 2024. এটিকে কিন্তু কোড করে দিও তো following orders. Page 56. The grievance of the petitioner is that after such order being passed by the Pradhan, the subdivisional officer has not taken steps for demolition of the structure. Admittedly, the matter of demolition of illegal structure, admittedly, the court taking of contempt matter is session. Taking up contempt matters is session with regard to the issue of demolition of illegal structure. It is informed by the learned advocate for the petitioner that subdivisional officer Bonga North Chobish Pargona is also contempt number 2 in the contempt application. Accordingly, it would not be proper to interdict since the matter is pending before the contempt. In view of the above,
My lord,
the writ petition stands dismissed.
Lord, without in
Is
case dismissing, my lord, kindly grant liberty to approach, my lord, and also kindly,
liberty is there? You have already made him a party, and then after you have filed an application.
my lord, kindly record the
Dismissed.
my lord, there is some urgency, my lord, so that I can make my submission. My lord, it will
Sir,
be-
it is for the convenience. Don't embarrass the court like this. It's the convenience of the court will take up.
there is some urgency,
But
my lord.
you go and approach the court. If the court permits you, will make you. Acha, on the prayer of learned advocate for the petitioners, leave is granted to file supplementary affidavit. Supplementary affidavit filed on behalf of the petitioner is taken on record. It over the other. ये दाঁড়িয়ে আছে হাতে থেকে এবার অরিজিনাল সাইড আছে ডেকে দাও ডেকে দাও
Item number 238. 34.
What is your matter? 85
85 তো most
টপ বলেছি টপে কালকে রেখে দাও টপে রাখো কালকে টুমরো এটা কন্টিনিউ করো কালকে টপে আছে কিছু এইটা থাকবে জাস্ট মিনিট
কি আছে ওকে আছে
এটা কন্টিনিউং ম্যাটার আছে এটার পরে ওটাকে লিস্ট করো 85 এর পরে this will be a top matter after that দাঁড়াও ডাকো কালকে কি 25 আছে এটা 20 your matter is 24
Year of 24th.
ইয়ার অফ 24 কবে দেবে তাহলে? ওকে টপে নিয়ে এসো। নেক্সট ওয়েডনেসডে টপে 30th April.
Well, we marked in the list that will be next Wednesday.
I have directed them, it will be on top on 30th April, the first item. দেখো 30th April আর অন্য রাখবেন মোশন, এটাকে টপে রাখবে। You are for? And service has been affected?
Services.
Oh. Yes.
34. Control board letter registering.
Private respondent. Sweet shop. Yes.
There are three private respondents. That's respondent number 9, 10, and 11. My learned friend is representing 10 and 11, but they have already filed their report. And from the report filed by my learned friend as well as by the state, my lord, it appears that they have complied with the conditions and the restrictions as was imposed by the Pollution Control Board. But in respect of my lord, respondent number 9, who is still date absent before this court, my lord, no steps has yet been taken by him. And he is, my lord, continuing with the creation of pollution. Right.
And what is the steps taken by the Pollution Control Board against respondent number 9?
Pollution Control Board passed an order directing the, kindly come have a look to page 25. Certain directions were given upon the block development.
Action
office.
taken report.
Read petition, man. Read petition itself. Read petition annexure P3, page 25.
Yes.
The observations are there. Kindly come to page 26, my lord. Middle portion, bold letter, the block development officer, Barhampur Development Block is hereby informed that as per the Solid Waste Management Rules 2016, notified by the Ministry of Environment, Forest and Climate Change, so and so Government of India, the local authority shall arrange for door-to-door collection of, my lord, segregated solid waste from all households, including slums and informal settlements, commercial, institutional, and other non-residential premises. Further, no waste generator shall throw, burn, or bury the solid waste generated by him on streets, open public space outside his premises, or in the drain or water bodies. All these things are there. Now, the block development officer, Barhampur Development Block, to exercise his good office for redressal of the problem in accordance with the above stated rules and section 37 of the West Bengal Panchayat Act, Panchayat Gram Panchayat Administration Rules 2004, so that the site in question is not used as a place for dumping waste, etc. In terms of that one, they have filed a report. They said they need a place. They have asked for permission to purchase that place. All these things are there. Now, the private respondent number 10 and 11, my lord, they have installed certain measurements so that this can be reduced. And that's functioning till that's my inform. But in respect of 9, my lord, he is reckless. He reckless. Or I beseech before lordship, let a rule be issued against him. Let him presence be ensured before lordship.
Yes.
But I can only, my lord, I would be beseeching, my lord, whatever I have done, can you record it that I have complied with this order? So I can show from the records I have done everything. My lord, to find, my lord, lordship finds whatever I had to do, my lord, is the report by way of everything on behalf of respondent number 11. It's my lord finds.
That has already been accepted by the state also.
All, it is accepted, I do not need to.
The same thing has been reiterated by the state. So we are not raising any issue there.
Okay.
Let
As
the
far as
presence
his
of-
client is concerned, he has complied. We are not restricting.
কি গান করছো? আরে মিষ্টি নেবে তাও সুগার হয়নি তো।
Yes, pollution control board.
Lordship, state is Lordship main answering respondent, Lordship. In this matter, Lordship, Pollution Control Board has no role, Lordship.
Yes,
We have taken all actions. We have followed forbidden the panchayat to purchase land so that dumping can be. So there is no question of non-compliance of state in any part.
but then they say that 9 has not complied with the direction that was.
The Pollution Control Board, that has to be looked into. That has to be looked.
Why do you say that you have no action to be taken against respond number 9?
Respond number 9 action has to be taken by the Pollution Control.
Yes.
No, even the panchayat body can.
Panchayat,
Block
I'm not
development
appearing
also
for
can.
the panchayat.
They are running the business by the trade license granted by the panchayat.
I am not representing panchayat. I can't represent that rather.
Serve a notice upon the Pradhan through the block development officer. So the direction can be given as he says, and you also come up with the instruction as to what are the steps to be taken in violation of the instruction that was given to respond number 9 as well, along with his client. If it is violated, then you have to take steps and cancellation of license. That can direction be given if
And
it is not complied.
26, the last paragraph, the officer in charge, Barampur Police Station, is requested to observe the compliance of this order.
Order number?
Page 26, the last paragraph of my read petition, Mala. The order of the Pollution Control Board. The officer in charge, Barampur Police Station, is requested to oversee the compliance of this order and also see that all the 3 respondent unit names so and so do not operate without obtaining consent to operate of the state board.
Yes, that is the law. That is the
Yes.
law. Consent.
Someone is flouting this order, my lord.
If consent to operate is not there, it can't be done.
Yes.
Okay. Then Pollution Control Board will take instruction whether this has been issued to him, whether he has complied or not, and come back. If not, what are the steps taken before the officer in charge, Barampur Police Station?
Respondent number 6.
Whether any complaint has been made that, yes,
Is the respondent number 6 before lord?
Is there any complaint?
I don't know, he can apprise the court. Ashun. Mr.
Yes.
Muhammad Sarwar Jahan, learned advocate for the petitioners, at the outset informs the court that the respondent numbers, Mr. Chakraborty, respondent number 10 and 11.
10 and 11.
10 and 11 has complied the directions issued by the Pollution Control Board. However, respondent number 9. What is the name of that sweet song?
Ramakrishna Sweets.
Ramakrishna Sweets have not come. Change the name.
C and 9 is without C. That's why he's
বেশি ভক্তি মানে বাবা বেশি নন কমপ্লায়েন্স
সম্পর্ক কি বলছে রামচন্দ্র
say more bhakti, more non-compliance. Yours is Sri. So then you have, that's why you have complied.
Father's name is Lakshman, another is Manoj, father's name is
Stop.
Ramachandra.
Ramakrishna Sweets have not complied the directions issued by the Pollution Control Board. Para. On being inquired from the learned advocate representing WBPCB, learned advocate seeks some accommodation to take proper instruction as to the steps taken against respond number 9 in view of the non-compliance, if any. Next speaker again, Wednesday. After Wednesday তে রাখো হয়ে গেছে 30th April রাখো 30th April.
Let a report also be filed by the police authority.
পুলিশের এখন কি আসবে আগে লেটার
Let him come back with the instruction. Any steps taken by him, thereafter direction can be issued. Chalo. Originals. Originals. ঠিক আছে হবে।
Original side, item number 1 to 6.
Yes.
This is my application. Lordship will kindly take your lordship's last order dated 11th of September 2024. By that order, your lordship had granted leave to the applicants as well as to the respondents to write to the various banks to disclose the status of various accounts of the deceased. Demat account, mutual funds, etc. Lordship will kindly take the last page of lordship's order.
The proposed statement of accounts are being approved. Oh. What happened then?
Now, apropos that, we had written and the bank has given us, furnished us with various statements. I have filed a supplementary application. Your Lordship, I'm handing out.
Who is on the other side? Mr. Gupta?
I have served the copy of supplementary affidavit as well. Mr. Gupta was approved on the last petition. May I hand up the copy of the supplementary affidavit? Now, in the supplementary affidavit, apropos your lordship's order, we had written to the banks and the banks have furnished us with various statements. Now, from the statements, may I just in brief submit? Now, from the statement, it shows, it evinces that various amounts are due, various amounts are standing in the name of the deceased. Now, regarding these accounts, there is no dispute between the parties. That I will show from the previous letter of the respondent. The parties are also addendum that insofar as these accounts are concerned, there is no dispute. Lordship will take in that order of September 11th, 2 letters are referred to your lordship. At the very first page of the order, letter dated 19th August and 9th September.
Yes.
Now, if your lordship kindly takes the letter of my learned friend dated 9th September at para 4.
Para 4 of?
The letter dated 9th of September.
No, where is that letter?
That letter is already on record that shows from the order. May I hand over a copy?
No, this letter has been annexed to the supplementary. Supplementary has it?
No, that letter, because it was already brought on record, it was not on the
দেখো আর কি আছে দেখ লেটারটা ফাইল করেছিল লেটার ওয়াজ ফাইলড দেখো দাও আমাকে দিন
9th September.
Yes.
Now, para 4, and this is apropos our communication. They write, Mrs. Roma Shane will be entitled to 1/3 share of the following properties of the deceased. Now, your lordship will see NPS account, public provident fund account, mutual fund, shares in demat account of IIFL. It's undisputed between the parties. Now, the bank has given us, furnished us with the details and particulars of these accounts. Lordship will kindly take page 46 of my supplementary affidavit. So there is no dispute insofar as these accounts are concerned. Page 46 is the statement of IIFL Securities Limited. It starts at page 46. Your lordship will kindly take straight away page 56 and 57, which provides the summation of the total claim, total amount standing in the name of the deceased as on 16/10/2024. Page 56 at the bottom of the page, your lordship. Statement of holdings as on date 16/10/2024. Your lordships have found that. And if your lordship turn over to the next page, the total amount, total valuation as at 16/10 is 8,51,03,585.67. This is undisputed. Now, if your lordship kindly takes at page 68, the Axis Mutual Fund statement. This is the statement as on 27th of September 2024. Page 68.
Yes.
Now, your lordship will find statement on 27th September 2024. Your lordship, your account at a glance, the table at the bottom of the page. Your lordship will see
Yes.
Axis ELCC tax saver fund, regular growth, lock in 3 years, total amount is, your lordship, 16,25,071 rupees 55 paisa. Now at page 86, the NPS account, again, the value of NPS holding as at September 27 is 20,28,946. So these accounts, these three statements that have been furnished by the banks, both parties are at item that regarding this, there is no dispute. The dispute today remains only regarding the life insurance nominee aspect, which your lordship has recorded, will have to be heard out, and the expenses, regarding the accounting for the expenses. Insofar as this is concerned, 9th September order would show that there is no dispute between the parties. Now your lordship recalls, this is the application on behalf of the mother of the deceased, who is about equal years of age and suffering from cancer. She also needs some maintenance. Now the widow always had access to the funds, apropos a previous order of the court. To spend amounts for the upkeep and maintenance of the child and the mother. Now, insofar as the deceased's mother is concerned, I have no such facility. This corpus is undisputed between the parties. All I'm requesting, because there is no dispute pertaining to this, these accounts, with the consent of the parties, can be distributed between the parties. I only need my 1/3. And to that, there is no dispute. Your lordship will once again see the letter of 9th September. Very categorical statement made, and it has never been any dispute.
Yes, yes.
Other issues involved barring this. First, there are flats.
I think this cannot be resolved. Who are to file this caveat affidavit in support of caveat? You are the caveator.
We have filed.
You have filed your affidavit.
Yet,
Yes.
never filed.
We have filed an application for extension of the.
That application was being.
That application, I will post it for hearing. File your affidavit. Let it be contested. Because this compromise, I don't think some disputes would be there. It cannot be compromised. And
Subject to correction.
There are three issues.
if the consent is given by the parties, that is non-contentious. On consent, the probate cannot be granted.
May I indicate? There are three components involved.
See, one thing is clear that you cannot compromise the probate proceedings. One thing you keep.
It's not a probate.
Just a minute.
There is no way.
Let me place thereafter. You make your
I'm
submission.
sorry.
One thing is, if you give your consent to that proceedings, it becomes a non-contentious, and as per the will, that will be executed. That will be given.
But here there is no will.
What
There
is
is
there?
no will here. It's a letter of administration without will.
Without a will
Oh.
annexed.
Yes, now submit.
Well, there are three components here. One is the bank accounts. The other is the mutual funds and the other things. The main is the issue with regard to the insurance. Whatever has been received. Another component is the are the flats.
Okay.
So we have taken out an application for selling of the flats because there are certain flats which
I'm in possession of one flat. 2 flats are in possession of the wife.
the flats.
I'm not getting into any dispute. I'm asking it insofar as the undisputed corpus is, let them take 2/3. I'm not bothered. And I'm an 80-year-old suffering from cancer. Let me take my 1/3. But otherwise, there is nothing for me in it anymore. I'm ready to give up because insofar as this corpus is concerned, this is undisputed. They exceed the banks.
Application to the application.
So today, your lordship will also see the fights of the respondents. I'm making a more than fair assertion that it is undisputed. So let them take 2/3. Give me my 1/3. And all throughout, statements have been made that we don't want the settlement to go through. We are creating a problem. all throughout. This statement has been made. Today, I'm making a statement that undisputed 1/3, they have acceded, they have agreed. That is undisputed 1/3. Can you stop speaking by the side? All I'm very well. So all I'm asking is undisputed corpus of 1/3, and I'm ready to not assert any claim on 2/3.
Yes, Mr. Gupta.
If the settlement whole hog happens, we are ready. Problem is, they have seen some money in the bank account and they are saying this is undisputed. They are not willing to resolve the disputes so far as the flats are concerned and so far as the insurance claims are concerned. So far as the insurance claims are concerned, now the law has changed. Now the person who is the nominee is no longer a receiver nominee, but is the beneficial nominee who is entitled to get the entire proceeds from the insurance policy. So there's an issue with regard to that. We have taken out an application with regard to sale of the 3 flats. Now, my lord, one flat, the mother-in-law is residing. 2 other flats are there where I am the owner, 50% owner with my husband. So the mother-in-law has certain share, 1/3 of the remaining 50%. The mother-in-law, the flat in which the mother-in-law is staying, that is also owned by the husband and my client. So, my lord, these flats need to be valued and sold, and or the whoever retains, if the mother-in-law chooses to retain one, then accordingly the valuation has to be arrived
There
at.
is no dispute regarding this. I'm making an unequivocal statement.
So there is an
There is no
application
dispute regarding
which is being
ownership.
opposed for
No.
all along.
Because they
My
have
application
paid
is
for
here.
sale
It's
and
yes.
eviction. How can that happen?
I have applied for sale.
File.
I can adjust. There is no dispute.
Which is
regarding
your application for filing the affidavit?
My application.
Give the number.
the
You have serve a copy.
The application for discharge of caveat is mine, Your Lordship. And they have filed their opposition to that. And the hearing in that matter had commenced. That is my application for discharge of their caveat that they had filed prior to filing of the application for grant of letters of administration. And it evinced that there was no affidavit in support. Grounds are there that can be heard out. But insofar as flats are concerned,
But then they have also filed an application for extension of time to file affidavit.
that is the same. That is a counterblast to my application for discharge. They have to be
We
heard
have
together.
filed first.
Maybe.
We had
But-
filed first.
Oh, do the application.
file
What
counter
is the application number?
Ah.
This is appearing.
Yes, all applications.
All applications are appearing.
This is GA1.
GA3 is
4 and 5.
GA3 is the application for sale of
No,
flats.
But
Kindly takes a look at my
no. Insofar as the application for discharge of caveat is concerned, that is GA5 and GA6.
extension of time to file lodge.
GA6 is
is
my
GA5?
application for discharge.
GA6 is the
GA5 is
application.
their prayer for extension. It is not extension, Your Lordship. If Your Lordship takes the prayer, the prayer is actually leave be filed, affidavit in support, ad interim orders. An order be passed, it is serve a copy, leave be granted to file caveats. Not extension.
If
Fresh caveat.
if
to
I have
file
not been
fresh
served
caveat.
with PLA, to what can I file the
They had already
affidavit in support of caveat?
subsequently it was recorded that the caveat actually was lodged back in the day in 2018.
Any affidavits have been exchanged in both
Yes.
these?
Yes, complete. Both are
Hey,
ready for hearing.
Let both these applications be taken up for hearing also. Today, you make your submissions with regard to 5. Discharge of caveat.
May I come back with both on one single day, Your Lordship? Then we can crash out. Because today my intention was
No.
to see if 1/3 can be shared and 2/3 can be
Let
given
the
to them.
applications be disposed of. Let us get into the proceedings. One after the other, days are being fixed for compromise. Nothing is coming out.
Let the applications be fixed.
We were wanting to argue on the point whether the insurance it should be divided or whether the beneficial nominee will get.
Going into that, the discharge of the caveat, my application, let that be taken up. That is the point.
Yeah.
Let that be taken up. Any
Very well.
short
Then there is
statement?
no settlement.
No
Then we shall
settlement.
proceed accordingly.
No settlement. Very well. Clear. It's clear. It's clear.
Every day you are coming, huh? Both the learned advocates were making submissions and matter will be settled. Nothing is coming out. It's wasted.
We have made every endeavor.
How many
Your
orders have
My
been
lord,
passed?
it was so far as the extent of the estate is concerned, there was no dispute between the parties,
There was always
barring
a dispute.
one issue, which is insurance. So I was, my lord, so it fell from your lordship
Hmm.
that issue needs to be decided.
Apart from that, there is virtually no dispute, but they don't want any distribution. That's the point.
Upon hearing the learned advocates for the parties and on their consent, list GA 5 of 2023 and GA 6 of 2023 for hearing on date বলুন hearing কোথায় গেল অ্যাপলেট সেই কেমন আছেন এগুলো হ্যাঁ ভালো আছে affidavits have been filed in both the applications
Affidavits are complete.
দেখুন তো 8 May 8 15 হতে পারে
15th of May. Is it your lordship's pleasure to fix a time?
yes 15 কি বার আছে ওটা থার্সডে রিটার্নেবল মোশনের পরে 4টে 4
I'm very deeply obliged. I'll
14.
attach my
you take this one এটা ওনাকে দিয়ে দিন হ্যাঁ কি বলছেন কোনটা
I'm grateful.
ও এটা নোট করুন সাপ্লিমেন্টারি অ্যাফিডেভিট this was directed to be filed or
Yes, yes. We had filed apropos these steps that have been taken pursuant to your lordship's order.
on the prayer of learned advocate for the petitioner leave granted to file supplementary affidavit supplementary filed on behalf of the petitioner taken on record copy served
I'm jumping.
এটা পিএলএ হেডিং করে দেবেন সাপ্লিমেন্টারি হ্যাঁ পিএলএ নাম্বারের হেডিং করে দেবেন সাপ্লিমেন্টারি
Let me leave yesterday to come and mention it at 4 p.m. That friend is also here, I informed. My lord, this matter was part heard before, my lord. Any date, my lord, please just, my lord, may keep it. We shall conclude.
তাহলে কবে দিলাম ওটা 15 তারিখে
His part of submission was completed. I have to give reply.
And if required, I will give a short notes because only to recapitulate whatever had submitted, I'll give a short notes.
আচ্ছা কোথায় গেল কবে দেবো is BIP হপ্তাহে হবে না 8 তারিখে দিয়ে দিন 8th May 4 p.m 8th May 4 p.m after he concludes you make your short reply to if anything else.
Yes. Their contention was that I am the natural.
You have no caveated
I am the son. I am the son. In spite of that, they, as per their allegation, is that I have challenged the title of the testatrix. It is not. I will demonstrate that.
on 8th May 4 p.m